Is the actual pharmacist here your boss?
I am the pharmacist and the boss.
You own this place?
Yes, for 3 years now.
Huh, okay, sure. Well, like I said, I need those records now.
And like I said, those records are protected under HIPAA.
Right.
I legally can't show them to you.
Pharmacist Dr. Michelle Carter was working behind the dispensing counter at Riverside Pharmacy at 2 in the afternoon on a Saturday in March when a uniformed police officer walked through the front door. Michelle was 39 years old, had been a licensed pharmacist for 15 years, and held a doctorate in pharmacy from the University of Michigan. What most people didn't know about Michelle, including the officer who was about to approach her with a demand that would change her life, was that she also had a law degree from Harvard Law School, having completed her JD while working as a pharmacist, specifically because she was fascinated by the intersection of health law, patient privacy, and constitutional rights. She had never formally practiced law, but her knowledge was as deep as any practicing attorney's. Michelle was processing a routine prescription for an elderly customer when she noticed the officer standing near the door observing the store. She completed the transaction, bid farewell to the customer, and then the officer approached the counter. His badge identified him as Officer D. Matthews from the local police department. Matthews appeared to be in his early 30s, average build, and carried himself with the casual authority that suggested he was accustomed to immediate compliance. He placed what appeared to be an official document on the counter and said he was conducting an investigation and needed prescription records for a specific patient. Michelle looked at the document, which was a simple request form on police department letterhead, but it was not a court warrant or subpoena. Michelle politely asked if Matthews had a warrant or subpoena for the records. Matthews said no, that he didn't need one, that his request as a law enforcement officer was sufficient. Michelle calmly explained that pharmacy prescription records were protected health information under HIPAA, the Health Insurance Portability and Accountability Act, and that she couldn't disclose them without appropriate patient authorization or valid court order. Matthews became visibly irritated. He said he was conducting a criminal investigation, that he had authority to request records relevant to that investigation, and that her refusal to cooperate was obstruction of justice. Michelle maintained her professional composure, but felt the familiar tension of confrontation with authority that didn't understand or didn't care about the legal limits of its power. Michelle told Matthews she understood he was conducting an investigation, but that patient privacy wasn't something she could compromise based on a verbal request from a police officer. That HIPAA had specific exceptions allowing disclosure to law enforcement, but those exceptions required appropriate documentation. That he needed to obtain a subpoena or court warrant, or he needed to demonstrate one of the emergency exceptions applied, such as immediate threat to public health and safety. Matthews said he wasn't going back for paperwork because this investigation was urgent, that the patient in question was a suspect in a drug diversion case, and that every minute Michelle delayed providing records potentially allowed the suspect to destroy evidence or continue criminal activity. Michelle asked for the name of the patient Matthews was investigating. Matthews said that information was part of the investigation and he wasn't going to disclose it unless Michelle agreed to provide records. Michelle pointed out the circularity. She couldn't provide records for a patient whose name she didn't know. Matthews then wrote a name on a piece of paper and pushed it across the counter. Michelle recognized the name immediately because she had personally filled a prescription for that patient just 3 days earlier. It was a legitimate opioid prescription prescribed by a respected pain management physician for a documented condition. There was nothing obviously suspicious about it. Michelle told Matthews she had reviewed that patient's prescriptions, and they all appeared appropriate and legitimate. Matthews said he wasn't asking for Michelle's medical opinion. He was demanding records as part of an official investigation. His voice was rising, his tone becoming more aggressive. He said if Michelle didn't provide the records immediately, he would arrest her for obstruction and obtain the records through a search warrant that would disrupt her entire business and embarrass her in front of customers. Michelle felt the impulse to give in, not because he was right, but because confrontation with a police officer in power was intimidating even when you knew the law was on your side. But then she remembered exactly why she had gone through law school while working full-time as a pharmacist. It was precisely for moments like this when governmental authority demanded compliance with an unlawful request and used intimidation to obtain obedience instead of following appropriate legal procedures. Michelle calmly told Matthews she wasn't obstructing his investigation, but was fulfilling her legal obligations under federal privacy law. That HIPAA specifically prohibited pharmacists from disclosing protected health information to law enforcement without appropriate documentation. That violation of HIPAA could result in substantial fines for her personally and for the pharmacy, plus potential loss of her professional license. That she was happy to cooperate fully with his investigation as soon as he provided appropriate subpoena or warrant, which any judge would issue quickly if he really had probable cause to believe a crime was being committed. Matthews said he didn't have time to jump through bureaucratic hoops, that this was an urgent law enforcement matter. Michelle then did something that caught Matthews completely by surprise. She said since he was insisting he had legal authority to demand records without warrant, she was going to need him to cite the specific statute or case law that gave him that authority. Matthews looked perplexed. He said he didn't have to cite law, that he was a police officer and had inherent authority to request evidence in investigations. Michelle politely but firmly said no, that police officers didn't have inherent authority to invade federally protected medical information privacy. That if he believed he did, she would like him to specify the legal basis because she had studied HIPAA extensively and wasn't aware of such an exception. Matthews changed tactics. He said he was requesting records under authority of state-controlled substances law, that pharmacists had to report suspicious activity involving controlled substances to law enforcement. Michelle nodded and said he was partially correct, that pharmacists did have an obligation to report suspicious activity under state prescription drug monitoring programs, but that was a separate reporting obligation, not authority for an officer to demand records without warrant, and that she had already reviewed the prescriptions of the patient in question and didn't find them suspicious, so there was no reporting obligation. Matthews said she wasn't qualified to determine what was suspicious. That's why he was investigating. Michelle explained she was literally qualified to make that determination. It was a core part of her professional responsibilities as a pharmacist to review prescriptions for appropriate legitimacy, possible drug interactions, and warning signs of abuse or diversion. That she had completed a doctorate in pharmacy and continuing education specific to fraudulent prescription recognition. That if she had determined prescriptions were legitimate after her professional review, then there was no basis for reporting obligation. Matthews said Michelle was being deliberately difficult, that she clearly had something to hide if she was so determined to protect this particular patient's records. He asked if she knew the patient personally, if there was some relationship she was trying to protect. Michelle felt the accusation shift from refusing to cooperate to suggestion of personal misconduct. She said firmly she didn't personally know the patient, that she was protecting patient privacy as required by federal law, and that Matthews' suggestion she was involved in some form of misconduct was defamatory. That she had met every appropriate professional and legal standard while he was attempting to violate federally protected privacy without appropriate legal authority. Matthews said if she didn't provide records, he was going to obtain a search warrant, and when he did, he would ensure investigators reviewed every prescription she had ever filled, looking for irregularities. That sounded like threat of retaliatory harassment. Michelle picked up her cell phone and began recording the interaction. Matthews immediately said she couldn't record him, that she was violating his privacy. Michelle, who had studied constitutional law as part of her JD, informed him she had an absolute right to record a police officer performing official duties in a public business. That right had been confirmed by multiple federal court decisions. Matthews reached as if to grab her phone. Michelle pulled it back and said any attempt to take her phone or prevent her from recording would be a violation of her First Amendment rights, and potentially assault if he touched her or her property without permission. The situation was rapidly escalating from demand for records to potential physical confrontation. A customer entered the pharmacy at that moment, an elderly woman who clearly needed help finding over-the-counter medication. Michelle told Matthews she had to help her customer, that it was her professional obligation to provide pharmaceutical care. Matthews said he wasn't finished with her, that she was going to wait until he decided how to proceed. Michelle said he was welcome to wait, but that she was going to fulfill her responsibilities to paying customers. She walked from behind the dispensing counter to the over-the-counter section, her phone still in hand and recording, capturing Matthews standing frustrated at the counter. She helped the customer, recommended appropriate product, and returned to the dispensing counter where Matthews was still waiting. Matthews had apparently used that time to call his supervisor. When Michelle returned, he was hanging up and looked even more determined. He said his supervisor had confirmed he had authority to request records as part of criminal investigation, and that Michelle was going to provide those records now or face consequences. Michelle asked if the supervisor was willing to provide that direction in writing, citing specific statutes that superseded HPA. Matthews said he wasn't going to request that verbal order was sufficient. Michelle said she needed appropriate documentation for her records before disclosing protected health information, that patient privacy protection wasn't something she compromised based on verbal statements. Matthews then made a move to go behind the dispensing counter. Michelle immediately said he wasn't permitted to enter the dispensing area without authorization, that was a secure area containing controlled medications and confidential patient information, and that his entry without appropriate warrant would be trespass. Matthews said he didn't need permission, that he was law enforcement. Michelle said his status as law enforcement didn't give him right to enter private areas of business without warrant, especially area containing controlled substances and protected medical records. She positioned herself in the counter opening, physically blocking his access, her phone still recording. Matthews said Michelle was now physically obstructing a police officer, that was a crime. Michelle said she was defending private property and protected information from unauthorized entry, that was her legal right and professional obligation, that if he tried to force his way past her, that would be assault and she would pursue charges, that she had offered multiple times to cooperate as soon as he provided appropriate legal documentation, and that his refusal to obtain that documentation demonstrated he knew his demand had no legal basis. Matthews looked at her with a combination of anger and frustration, clearly unaccustomed to having his authority challenged so directly, especially by a civilian pharmacist. A second customer entered, a middle-aged man with a prescription to be filled. Michelle excused herself from Matthews and moved to help the customer. Matthews followed her along the counter, continuing to demand records. The customer noticed the tension and asked if everything was okay. Michelle said professionally she was dealing with a law enforcement matter and would fill his prescription momentarily. Matthews told the customer Michelle was obstructing a police investigation. The customer looked confused from Matthews to Michelle. Michelle calmly explained she was protecting patient privacy as required by federal law and that the officer was demanding medical records without appropriate warrant. The customer, who happened to be a retired attorney, immediately understood the situation. He told Matthews the pharmacist was absolutely correct, that HIPAA required warrant or subpoena for disclosure of medical records to law enforcement except in specific emergency circumstances. Matthews said this was an urgent criminal investigation. The attorney asked if there was immediate threat to life or safety that would qualify for HIPAA emergency exception. Matthews hesitated, then said the suspect was engaged in ongoing drug diversion. The attorney said that didn't qualify as emergency under HPA, that Matthews needed to go through appropriate legal channels. Matthews said he wasn't going to take legal advice from random pharmacy customer. The attorney introduced himself as Professor Emeritus of Law from the local law school, specializing in health law. Matthews's expression suggested he realized the situation was sliding even further out of his control. Matthews finally left the pharmacy, but not before telling Michelle she hadn't heard the last of this, that he would return with a warrant and ensure every aspect of her dispensing practices was scrutinized. Michelle said he was welcome to return with appropriate legal documentation anytime, and that she kept meticulous records that would pass any review. After he left, the law professor congratulated Michelle on properly standing her ground. He gave her his card and said if she needed legal assistance or expert witness testimony about HIPAA compliance, he would be happy to help. Michelle thanked him, filled his prescription at no charge as a sign of appreciation, and then immediately began documenting everything that had happened. Michelle spent the next hour writing a detailed account of the encounter, including every demand Matthews made, every threat, his attempt to enter the dispensing area without authorization, and his attempt to prevent her from recording. She backed up the video from her phone to multiple locations, including cloud storage. Then she called the pharmacy owner, Mr. Robert Chen, who owned a small chain of 3 independent pharmacies. Chen listened to the story with growing concern. He said he completely supported Michelle's decision to protect patient privacy, that she had done exactly what she should have done, and that he would contact the pharmacy's attorney immediately. The pharmacy's attorney, Patricia Rodriguez, called Michelle within an hour. Patricia specialized in health law and had represented pharmacies in regulatory disputes for 20 years. She listened to Michelle's description of the incident and reviewed the video. Patricia said Michelle had handled the situation perfectly, that she had cited HIPAA correctly, had offered to cooperate with appropriate documentation, and had protected both patient privacy and pharmacy property appropriately. Patricia said she would write a formal letter to the police chief detailing the incident, educating the department about HIPAA requirements, and putting them on notice that future attempts to obtain patient records without appropriate authorization would result in legal action. Patricia also recommended Michelle file a complaint with the Office of Civil Rights at the Department of Health and Human Services, which enforced HIPAA. The complaint would describe Matthews' attempt to coerce unauthorized disclosure of protected health information, creating a federal record of the incident. And Patricia suggested Michelle consider a complaint with the State Board of Pharmacy, not against herself, but documenting an incident where law enforcement attempted to pressure a pharmacist to violate professional obligations. All of these actions would create layers of documentation and oversight that would protect both Michelle and the pharmacy from potential retaliation. Patricia's letter to the police chief was sent 2 days later. It was an 8-page document that politely but firmly explained HIPAA requirements, cited specific statutes and regulations, detailed Matthews' behavior including warrantless demands, attempted unauthorized entry into dispensing area, attempt to prevent legally protected recording, and threats of retaliation. The letter noted Officer Matthews had apparently received confirmation from a supervisor that he had authority to demand records, suggesting the training problem was broader than individual officer. The letter requested the department provide comprehensive training to all officers on HIPAA requirements and appropriate procedures for obtaining medical records. The police department's response came a week later. It was brief and defensive. The police chief said Officer Matthews had been conducting a legitimate investigation of suspected criminal activity, that the department took such investigations seriously, and that officers had authority to request evidence relevant to investigations. The letter didn't address the specific HIPAA issues Patricia had raised, didn't acknowledge Matthews's demands had been improper, and didn't offer any commitment to improve training. Patricia told Michelle the response was exactly what she feared, indicating the department didn't understand or didn't care about legal limits of its authority in the context of protected medical records. Michelle and Patricia decided the department's inadequate response required stronger action. They filed a federal lawsuit under Section 1983 for violation of Michelle's Fourth Amendment rights against unreasonable search and seizure of information and under state privacy statutes. The lawsuit named Officer Matthews personally and the police department. The allegations were detailed and technically precise. Matthews had attempted to obtain protected health information without appropriate legal authorization. He had threatened Michelle with arrest for fulfilling her legal obligations under HIPAA. He had attempted to physically enter a secure area containing controlled substances and confidential records without warrant. He had attempted to prevent Michelle from exercising her First Amendment rights to record the encounter, and he had threatened retaliation through harassing investigation of her professional practices. The lawsuit also included a count under Manel policy, custom, or practice theory, arguing the department's response to the incident demonstrated systemic failure to train officers on HIPAA requirements and constitutional limits of their authority to obtain medical records. Patricia had documented that the department conducted an average of 20 drug diversion investigations per year, but had no formal training protocol on how to legally obtain medical records. That officers apparently believed they could simply demand records from pharmacies and healthcare providers without following appropriate legal procedures, and that the chief's defensive response to the letter demonstrated the department didn't take these legal concerns seriously. The lawsuit sought $500,000 in damages, but more importantly, sought declaratory judgment establishing Matthews's attempts to obtain records were constitutionally improper, and injunctive relief requiring the department to implement comprehensive training on high pay and medical privacy for all officers. Patricia had drafted the lawsuit to be both legal action and educational document, including a 15-page appendix explaining HIPAA requirements, appropriate procedures for law enforcement to obtain medical records, and why these protections existed to protect both patient privacy and integrity of the doctor-patient relationship. The story leaked to local media within days of the lawsuit being filed. An investigative journalist from the local news station had been monitoring court records and recognized the story's significance. Pharmacist with Harvard law degree defending patient privacy against police officer demanding records without warrant, all captured on video. The reporter contacted Michelle, requesting an interview. Michelle consulted Patricia, who said it could be beneficial to make this public to educate other healthcare professionals about their rights and obligations. Michelle agreed to limited interview, focusing on the law rather than specific details of pending litigation. The interview aired on the evening news. Michelle appeared professional and measured, explaining HIPAA requirements in clear, simple terms. She said healthcare professionals had legal obligations to protect patient privacy, that those obligations didn't evaporate just because a police officer made a demand, that there were appropriate legal procedures for law enforcement to obtain medical records when necessary for investigations, and that those procedures existed to balance legitimate law enforcement needs with fundamental privacy rights, that she had offered to cooperate fully once appropriate documentation was provided, but that the officer had refused to follow those procedures and instead attempted to coerce, intimidate, and threaten. The station played portions of the video, showing Matthews demanding records and Michelle calmly citing HIPAA. Public reaction was immediate and widely favorable to Michelle. Healthcare professionals from across the state shared similar stories of law enforcement demanding records or information without appropriate authorization. 3 other pharmacists contacted Patricia's firm describing incidents where officers from the same department had demanded prescription records without warrants, and they had complied because they didn't know their rights or were intimidated. A physician described being threatened with obstruction when he refused to provide patient records without subpoena. The State Pharmacy Association issued a statement praising Michelle for upholding patient privacy and professional standards and announcing they would develop training materials helping pharmacists understand their rights and obligations when contacted by law enforcement. The police department tried to settle quickly. Their lawyers knew they had a deeply problematic case. Officer recorded demanding protected medical records without warrant, pharmacist with Harvard law degree who knew HIPAA better than most attorneys. Clear video showing Matthews's attempts to intimidate, threaten, and coerce. 3 additional witnesses with similar experiences establishing pattern, and massive public sympathy for healthcare professional protecting patient privacy. The initial offer was $125,000, plus commitment to provide some training. Patricia rejected it as inadequate, saying it didn't reflect the severity of violations or address underlying systemic failure. Negotiations continued for months. The city increased the offer to $250,000. Patricia counteroffered $400,000 with specific and comprehensive policy reforms. During this time, depositions were conducted. Matthews had to answer questions under oath about his HIPAA training, which he admitted was minimal, about how many times he had requested medical records without warrants, which he estimated at dozens over his career, about whether supervisors had approved those requests, which he said yes, about whether he understood HIPAA was federal law with specific requirements, which he said vaguely. He knew there were some privacy rules, but law enforcement had exceptions. His deposition demonstrated profound lack of understanding about legal limits of his authority. Matthews's supervisor, Sergeant Bradley Connor, was also deposed. Connor admitted he had confirmed to Matthews he had authority to request records, but when pressed on legal basis for that confirmation, couldn't cite specific statute or regulation. He said it was standard department practice for officers to request records directly from healthcare providers when needed for investigations. When asked if the department provided training on high PA requirements, Connor said it had been mentioned briefly in academy training years ago, but no ongoing training. When asked how many times officers had obtained warrants or subpoenas for medical records, he estimated that happened in less than 10% of cases because the process was time-consuming. The police chief, Chief Martin Walsh, was deposed as well. His deposition was particularly damaging to the department's case. When asked about departmental policies related to obtaining medical records, he admitted there was no formal written policy. When asked about training, he said officers were instructed to use reasonable judgment. When confronted with the fact that multiple officers apparently believed they could demand records without warrants, Walsh said that was a misinterpretation of training. But when asked what training specifically covered HIPAA, he couldn't identify any. Patricia used that deposition to demonstrate the problem wasn't just Matthews individually, but systemic failure that exposed the city to ongoing liability. The final settlement was reached 14 months after the incident. The city agreed to pay $375,000 to Michelle. Matthews was personally liable for $25,000 through wage garnishments, though he had left the department during litigation to take a position at a smaller agency in a different state. But the monetary component was only part of the settlement. The policy reforms were where the real impact was. The department had to develop and implement comprehensive protocol for obtaining medical records, requiring officers to obtain warrants or subpoenas, except in genuine documented emergencies. Every officer had to complete 40 hours of training on HIPAA, medical privacy, and appropriate legal procedures conducted by outside instructors with health law expertise. The settlement also established a dedicated liaison position between the police department and healthcare community. This person, who had to have background in both law enforcement and health law, would be a resource for officers needing guidance on obtaining medical records and for healthcare providers receiving requests from law enforcement. The liaison would maintain a log of all medical record requests, review them for legal compliance, and issue quarterly reports to the chief and city council. This oversight mechanism ensured future requests would follow appropriate procedures and created transparency that had been absent. Michelle donated her portion of the settlement, minus legal costs, to establish a patient privacy education fund that would provide free training for healthcare professionals across the state about their rights and obligations when law enforcement requested information. The fund developed training materials, conducted webinars, and created a hotline healthcare professionals could call for real-time guidance when facing law enforcement requests. In the first year, the hotline received over 200 calls from pharmacists, physicians, nurses, and other providers facing similar situations. Many were able to stand their ground appropriately armed with knowledge the fund provided. The case Michelle Carter versus Matthews and Police Department became widely cited in health law and law enforcement circles. Law schools used it in courses on HIPAA and medical privacy. Police academies used it as an example of why understanding legal limits of police authority was crucial. Pharmacy training programs used it to teach students about their professional obligations to protect patient privacy, even when facing pressure from governmental authorities. Healthcare professional associations cited it when developing guidelines on how to respond to law enforcement requests, and privacy advocacy groups used it to demonstrate why robust protections and educated professionals were essential to maintaining medical privacy. Matthews left law enforcement completely within 2 years of the incident. He apparently found the environment at his new agency less welcoming after the story of him trying to coerce disclosure of medical records without warrants spread through law enforcement networks. He ended up working in private corporate security, 20% of each paycheck garnished to pay his debt to Michelle for the rest of his professional life. Some acquaintances expressed sympathy, saying he had just been trying to do an investigation, but others pointed out that trying to do work without following appropriate legal procedures wasn't an excuse, especially when those procedures existed to protect fundamental rights. Sergeant Connor, the supervisor who had confirmed Matthews's improper authority, was demoted to patrol officer and completed extensive additional training. He remained with the department, but was never promoted again. Chief Walsh faced significant criticism from the city council for allowing the department to operate without appropriate policies or training on HIPAA. He implemented all reforms required by the settlement, but announced retirement within a year, citing desires to spend more time with family, but clearly under pressure. The new chief who replaced him made medical privacy compliance and constitutional training central priorities. The training protocol developed as part of the settlement became a model adopted by multiple other departments across the state and eventually influenced state training standards. It covered not just HIPAA, but broader constitutional principles about when law enforcement could and couldn't access private information without warrants. It included scenario exercises where officers practiced obtaining appropriate warrants, distinguishing between genuine emergencies and routine investigations, and responding appropriately when healthcare providers cited privacy obligations. The training was reviewed annually and updated based on new case law and emerging best practices. The State Pharmacy Association used Michelle's case to launch a broader advocacy initiative on patient privacy protection. They worked with legislators to clarify state statutes, ensuring pharmacists had explicit protections against retaliation for refusing to disclose protected information. They developed training materials for all licensed pharmacists in the state, and they established a legal defense fund that would provide assistance for pharmacists facing legal actions or threats from law enforcement for standing up for patient privacy. These reforms strengthened the position of all healthcare professionals in the state to stand their ground against improper requests. Years after the incident, when interviewers asked Michelle about the case, she always emphasized the same points: that she had been fortunate to have legal education that gave her knowledge and confidence to stand her ground, that countless other healthcare professionals faced similar pressure without those resources, that protecting patient privacy wasn't an obstacle to legitimate law enforcement, but essential protection of fundamental rights, and that when law enforcement followed appropriate procedures, obtaining warrants or subpoenas, healthcare professionals cooperated fully. The problem was when officers tried to bypass those procedures through coercion and intimidation. Michelle continued working as a pharmacist at Riverside Pharmacy, now frequently consulted by colleagues facing law enforcement requests. She gave talks at pharmacy conferences, law enforcement training sessions, and community education programs about patient privacy. She always ended her presentations with the same point: medical privacy wasn't a luxury or bureaucratic inconvenience. It was a fundamental right that allowed people to seek health care without fear that private information would be disclosed without their knowledge or consent. And when that privacy was protected by professionals brave enough to stand their ground against improper pressure, it benefited every patient in the system. The video of the confrontation remained online, used in countless training programs. It captured a moment where everything abstract about HIPAA and medical privacy became concrete. Officer demanding records without legal authorization, pharmacist calmly citing law and refusing to cave to intimidation, retired law professor validating the pharmacist's position. And eventually, it captured the triumph of rule of law over misguided authority, of privacy over convenience, of knowledgeable healthcare professional over improperly trained officer who thought badge gave him authority to ignore federal law. The $400,000 total settlement and comprehensive reforms sent a clear message. Law enforcement couldn't simply demand medical records because investigation was inconvenient without following legal procedures. Healthcare professionals who stood up for patient privacy were protecting not just individual rights, but integrity of entire healthcare system. And when officers were improperly trained about limits of their authority, liability fell on both individual officer and department that had failed to provide that training. Michelle's case proved that knowledge was power, that education mattered, and that sometimes a pharmacist with a Harvard law degree was exactly the right person in the right place to stand up for rights that would benefit millions of patients who would never know her name.